Allahabad High Court APS Series B, Exercise 1 at the speed of 110 words per minute. Be ready? Start. This criminal original petition has been filed challenging the summons issued by the court below, directing the petitioner to attend an inquiry initiated by the court below based on the complaint given by the respondent under section 340 of the Code of Criminal Procedure 1973 bracket hereinafter referred to as CRPC. The respondent, who was arraigned as A3 in SC number 123 of 2005 before the Additional District and Sessions Court FTC 3rd, Chennai, faced trial along with three other accused persons for an offence under sections 120B, 307, 450, 451, 384, 506, Part 2 of the Indian Penal Code 1860 bracket hereinafter referred to as IPC, read with section 109 IPC. The FIR in this case was registered in crime number 473 of 2002 by the F2 police station Egmore, and later on the investigation was transferred to the file of the CBCID. The petitioner, who was then the Deputy Superintendent of Police CBCID, was assigned the task of investigating the case. It was based on the final report filed by the petitioner. The accused persons faced the trial before the concerned court. Stop para. The trial court, on appreciation of the oral and documentary evidence and after considering the facts and circumstances of the case, was pleased to acquit all the accused persons from all the charges through a judgment dated 23/2/2006. This judgment was taken on appeal by the CBCID before this court in Criminal Appeal number 52 of 2010. This court, by a judgment dated 22/6/2017, dismissed the appeal and confirmed the judgment passed by the trial court. Stop para. The petitioner thereafter filed a complaint before the court below in the year 2019 under section 340 CRPC against the de facto complainant and the petitioner herein on the ground that they have committed an offence under section 211 IPC, and the entire case was a malicious prosecution against the respondent. The court below, on receipt of the complaint, proceeded to issue summons to the petitioner to conduct an inquiry before acting upon the complaint. Aggrieved by the summons issued by the court below, the present petition has been filed before this court. Stop para. Mr. V. Lakshmi Narayan, learned counsel appearing on behalf of the petitioner, submitted that the petitioner had only investigated the FIR after it was transferred to CBCID, and the mere fact that the respondent was acquitted by the court will not attract an offence under section 211 IPC. The learned counsel further submitted that if the offence under section 211 IPC cannot be made applicable against the petitioner, there was no occasion for the court below to even conduct a preliminary inquiry by issuing summons to the petitioner. Stop para. Per contra, the learned counsel appearing on behalf of the respondent submitted that the findings given by the trial court and this honorable court in the criminal appeal clearly show that the entire case is false and the respondent has been intentionally roped in as an accused for having filed a habeas corpus petition questioning an illegal arrest made by the police. The learned counsel further submitted that the court below has only called the petitioner for a preliminary inquiry, and whatever grounds are raised by the petitioner in the present petition can be raised before the court below, and the court below will take a decision in accordance with law. Stop.